I will just wait one more minute or so while participants join. Thanks. Hello again. Well, welcome to our presentation. We'll get started now. We've titled our presentation today, 2025 Year in Review of Construction Law. Your presenters today will be my partner, Scott Lamb, and myself, Satinder Sidhu. We co-chair the Infrastructure, Construction and Procurement Group at Clark Wilson. Briefly, a little bit about us. We act for all parties in the construction contracting chain during the course of construction, everywhere from procurement to when disputes arise over construction of a project years later. So that includes drafting tender packages, drafting contracts, dealing with issues arising during the construction process, issues arising at completion or post-construction, including claims for defects, delays, termination. The group appears regularly in courts in BC and conducts mediations and arbitrations. We have a lot on our agenda today. We've got 5 different topics that we're going to take you through. Before we get into that, I just wanted to deal with a few housekeeping issues. We have a robust presentation today that we think is going to generate some questions. We hope that you could share your questions with us by way of the Q&A section of the webinar. And we will be leaving the questions to the end. Just a quick heads up in terms of my presentation. If we're getting quite a few questions about prompt payment, which we expect, I might switch gears and cut my builder's lien update a bit shorter, just to make sure that we have enough time at the end of the presentation to address all the questions. And also, Scott and I have got a few minutes after the presentation ends to continue to address questions. So with that, I'll get started. The 5 topics that we're going to take you through today include, of course, Bill 20, the proposed Construction Prompt Payment Act, a bit of an update on builders' lien cases that have been noteworthy over the last year or so. And then Scott's going to take you through delay claims, contract terms, and changes to certain CCDC, notable changes to certain CCDC documents. All right, so the Construction Prompt Payment Act. As many of you may know, prompt payment and adjudication legislation has been implemented across Canada in many other provinces. Bill 20 was introduced on October 7, 2025, and it proposes the enactment of the Construction Prompt Payment Act in BC. The intent of the legislation is to establish a scheme to help alleviate payment issues on construction projects so that money can flow down the construction contract chain faster, to also allow for not just payment of invoices on a prompt basis, but also to allow for timely and accessible adjudication of construction disputes. So what is prompt payment? So if a party provides services or materials to an improvement, much like a lien claimant would, and they issue a proper invoice for their work, the owner, according to the proposed legislation, must pay the contractor within 28 days of the invoice. Now, the parties below the owner and the contractor, the parties down the construction contract chain, are to be paid within 7 days of the party above them having received payment. Now, it's important when we're looking at, well, prompt payment and the regime to look closely at, well, what is it meant by, what does it mean by an improvement? Because the legislation only will apply to an improvement. Also, what does it mean by a proper invoice? Because the legislation will only apply if a proper invoice has been issued. So with respect to an improvement, the legislation will include the definition of an improvement. It's the same definition, almost the same definition as the definition of improvement under the Builders Lien Act, although they did add a clarification in the proposed legislation, and the clarification is that an improvement also includes any demolition or removal of those things that were demolished. That was missing from the definition of improvement in the Builders Lien Act. So I think that the drafters are trying to make that clarification by way of the new legislation. So in addition to the legislation applying to an improvement and work that's done on an improvement, the legislation also requires that there be a proper invoice. Well, what is a proper invoice? The Act will set out the information that needs to be included on a proper invoice. I won't go through everything, but of course, it's going to want it's going to want to have the parties indicate the period of time or the milestone to which the invoice relates, a description of the services and the materials. It also requires the information in the contract relating to how payment is to be made. And if the contract doesn't address how payment is to be made, the legislation says that the name of the person or the office to which payment is to be sent should be set out in the proper invoice. The proper invoice obviously is going to be subject to any prescribed information. So keep in mind that this legislation will likely have a robust set of regulations that follow along with it. Those regulations may add to what constitutes a proper invoice. The legislation also says that the proper invoice must meet any requirements under the contract. But one important thing to keep in mind is that any contract provisions that make the proper invoice conditional on certification by a payment certifier, or if there is language in the contract that requires the owner's approval before an invoice is properly issued, well, that language, those provisions are going to be void under the new legislation. So let's talk a little bit about the consultant then. Well, the consultant can still carry out the certification process for owners. And that's beneficial to the owner in the case that the owner wants to dispute that invoice. But payment certification and the failure of payment being certified is not going to be a defense any longer with respect to paying that invoice. That's not to say you can't dispute the invoice, and we're going to get to that in a second. So some other important provisions with respect to the new prompt payment regime is that the party is obliged to invoice regularly, invoice monthly, unless the contract provides otherwise, for instance, the achievement of certain milestones. The legislation includes interest provisions. Even if the contract is silent on interest, it provides that interest begins to accrue on amounts not paid at the higher rate of any prescribed amount under the regulations when they come into effect, or at the rate set out in the contract. And keep in mind that the Act doesn't amend pullback requirements under the Builders Lien Act. So even when a proper invoice is issued, and if no one disputes that invoice and it's paid, the 10% holdback still must be, the invoice is still subject to the 10% holdback under the Builders Lien Act. So the legislation has this robust set of rules that set out, the number of days in which a party is to be paid in the hopes of having money flow down the construction contracting chain a little more freely, but that doesn't mean that an owner or anyone else in the construction contract chain can't dispute an invoice. So an owner is required to pay an invoice if the owner is not required to pay an invoice if they give the invoicing party written notice of non-payment in a prescribed form by 14 days after the date of the invoice. And so that right to dispute flows down the construction contracting chain in the sense that down the chain, a contractor or subcontractor must provide notice of non-payment by the earlier of 7 days after they receive a notice of non-payment from the party above them in the contracting chain, or that party's calculated payment date for their invoice. So what happens next? A proper invoice has been issued. There might be a dispute over the amount of the invoice. I guess that disputed invoice could sit in limbo after notice of non-payment is issued. But the legislation provides for either party referring the matter to referring the disputed claim or the disputed invoice to adjudication. And then the legislation sets out what the adjudication process is going to look like. It involves one party providing written notice as dictated by the Act. The notice needs to include certain information, a description of the dispute, nature of what redress is being sought, and also the name of a proposed adjudicator. So now that we've moved into the adjudication phase of a dispute, well, what are some of the timelines surrounding adjudication? So an adjudication may be commenced during the construction project, but it can't be commenced more than 90 days after the contract between the owner and the general contractor is completed, abandoned, or terminated. So that's an adjudication as between an owner and a GC. With respect to any subcontracts, an adjudication cannot be commenced more than 90 days after the earliest of a number of triggering events. So the date the contract between the owner and the general contractor is completed, abandoned, or terminated. The date the subcontract is certified to be complete under Section 7 of the Builders Lien Act, or the date the subcontractor last supplied services or materials for the improvement under the subcontract. Well, what about the adjudicator? If the parties can't agree on an adjudicator, the adjudication authority appointed by the minister can appoint an adjudicator. Notably, the parties can't appoint an adjudicator themselves in advance in their construction contract. The adjudicator will charge a fee, which is meant to be split amongst the parties equally, unless by way of the adjudicator's determination, one party or the other should pay the fee. Now, what can the adjudicator do? The adjudicator can determine a number of different things. Whether the party has failed to make a payment after being invoiced a proper invoice. They can determine the value of services or materials pursuant to that invoice or otherwise. They can determine if payment is required for a change order, whether that change order is approved or not. They can issue directions in relation to the conduct of an adjudication. They can ascertain relevant facts and law. They can also conduct on-site inspections of the improvement. They can even obtain the assistance of certain consultants, accountants, building contractor, architects, engineers, or any other person to help determine the facts and questions and issues. And the adjudicator can even direct that the parties pay the costs of any third party or consultant used for assistance on a disputed matter. The adjudicator can also make determinations as to whether the dispute may be the subject of an adjudication, and if the adjudicator has jurisdiction to conduct the adjudication, because we can expect that with the Prompt Payment Act, the regulations will likely also indicate what kinds of projects or what types of improvements, what types of owners the Act is going to apply to, and that's where the adjudicator may have to make a determination as to whether they even have the jurisdiction to determine that dispute. So the adjudicator must make a written determination within 30 days of receiving certain records that are prescribed by the Act, or by a date as otherwise agreed to by the parties and the adjudicator. But this is interesting, that unless the parties consent, unless the parties and the adjudicator, unless the parties consent, the adjudicator can't unilaterally extend the time for the determination. And the Act actually says that any determination issued outside of these timelines is considered void. The decision of the adjudicator is binding on the parties, but it's very important to keep in mind that the adjudicator's determination is meant to be timely and expeditious and happen quick, usually, during the course of the construction. So keep in mind that that determination is only an interim determination. It can still be tried again by way of an arbitration or litigated in court. So that interim determination, though, any amount that a party may be ordered to pay has to be paid within 15 days after the determination is issued. The payment or the adjudicator's determination can't be stayed if the party then decides to go down the arbitration or litigation route. The amount to be paid has to be paid, and that can't be stayed, as other proceedings are often stayed in the court process while the matter makes its way through an arbitration or litigation. And now a dispute can be referred to an adjudication even if that dispute is already the subject of a legal proceeding or an arbitration. Now, what if a party doesn't agree with the adjudicator's decision before they're able to have that decision redetermined by way of an arbitrator or the courts? An adjudicator's decision can be judicially reviewed by our courts if a party takes a position that the adjudicator didn't have the proper authority to make the determination, or if they take the position that the determination was unfair or unreasonable for some reason. However, the adjudicator is protected from liability. So the Act says that unless the adjudicator acts in bad faith, that no legal proceedings for damages lie against an adjudicator arising out of the performance of their duty under the Construction Prompt Payment Act. So that is a summary of what the Act's intent is and how the drafters see the provisions playing out. Just as an aside, it does mimic Ontario's prompt payment legislation rather closely. So we can look to Ontario and the experience in other provinces with the prompt payment regime, and that will likely be the source of a future presentation from our group as this legislation makes its way through the legislature. It's in the second reading, I believe, right now. It'll likely take some time before the Act and the regulations come into force, and that'll give lawyers in the province and other stakeholders the opportunity to look a little more closely at what the experience has been in other provinces and see how this is going to impact our construction industry in BC. Now, a few other notes. Although this Act is going to operate parallel to the Builders Lien Act, it does include some provisions that amend the Builders Lien Act. I talked a little bit earlier about the definition of improvement. I'm pretty certain that the amendments to the Builders Lien Act includes also amending the definition of improvement under the Act to also include demolition. The Act, more notably, is going to abolish the Shimco lien in BC. Some of you may be familiar with the Shimco lien. It's unique to BC, where a party has an independent lien against the holdback that's required to be kept under the Builders Lien Act, in addition to their lien against the land. That lien is usually enforced by way of that lien must be enforced by way of a Supreme Court action. Now, the Shimco lien has been the subject of a lot of debate in BC, and many construction professionals disagree with this sort of alternate lien scheme. If you were to ask Scott or I, it really depends on who we're acting for at the time as to whether we agree with the Shimco lien, in BC, but that now will come to an end. And it is, like I said, it is unique to BC. So our Builders Lien legislation will align more closely with other provinces in Canada. So I've been allotted a few more minutes before Scott gets into his portion of the presentation. I'm just going to take a quick break to look at the chat, and I don't see, unless I'm looking in the wrong spot. Yeah, I don't see any questions having popped up with respect to, I don't see any questions having popped up with respect to prompt payment. Maybe participants are still, those questions are still swirling around there. So I will go ahead and carry on with the rest of my presentation. I won't cut it, I won't cut it short. I did want to talk about a few cases, a few notable cases with respect to the Builders Lien Act. These cases focus on discharging lien claims, complying with the Act, and breach of trust and director's liability. So I'll see if I can get through all of these cases. If I'm running into some timing issues, I may cut my portion of the presentation a bit short. So discharging lien claims. Many of you may be familiar with the different avenues with which you can discharge a lien claim. So a dispute arises mid-project, a lien is filed, the owner needs their construction financing, the bank won't extend financing until the lien is removed. How do you get the lien off quickly? Well, Section 24 of the Builders Lien Act allows a party to apply to court to cancel a claim of lien when there's a dispute about the amount being claimed by posting security for the lien. That security is usually held in court or in a lawyer's trust account. It's usually cash or a lien bond. And basically, the security gets deposited and then the parties can fight about the payment issues at another date. And so the entitlement to that fund is determined either by way of consent of the parties at a later date, making a further application to the court, or that matter could ultimately be, tried. That payment dispute could be tried in court. So under Section 24, our courts, generally speaking, have a wide discretion to consider the circumstances and to cancel that lien and post the security in an amount that the court deems to be satisfactory. And the objective behind Section 24 is to get that lien discharged and get that lien discharged quickly, so that the project and financing and other requirements can proceed. There's a second method by which a lien can be discharged, and that's Section 23 of the Builders Lien Act. And that allows a party to remove a lien and secure a discharge of the owner's liability for the lien as well, where the party did not contract with the lien claimant. And so I like to use, just when I'm explaining Section 23, I like to use this diagram. So for instance, the owner in this scheme, if a subcontractor has filed a lien, the owner in this scheme could discharge the lien and could also discharge the owner's liability going forward with respect to any of the lien claimant's claims by paying into court the lesser of either the total amount of the subcontractor's lien, because the owner may have that money held back from the general contractor in any event, or the amount owing as between the owner and the general contractor, so long as the amount owing between the owner and the general contractor is at least equal to the required holdback. And keep in mind that the general contractor can also remove liens under Section 23 in this filed by, let's say, the subcontractor, a party that they didn't contract with, in the same way by paying into court either the total amount of the subcontractor's lien or the amount owing as between the general contractor and its sub, so long as that amount is at least equal to the required holdback. So going back to the last slide, well, what is the required holdback? Section 4 of the Act sets out what the holdback amount should be. It's 10% of the greater of, and keep in mind it's 10%. So I just want to highlight that it's the greater of the value of the work or materials actually provided under the contract, or the amount of any payment made on account of the contract. So generally speaking, parties will withhold, when an invoice is issued and it's certified for payment or payment is approved, a party will issue payment on that invoice and then hold back 10% of that invoice. But keep in mind that under the Act, it's not it's not automatically just 10% of each invoice. It's actually the greater of 10% of that invoice or the value of the work or material actually provided. So the first case we're going to discuss dealt with when can the court determine what the amount to be paid is. When can the court determine what the amount to be paid is to do justice between the parties and discharge a lien and the owner's liability under Section 23 of the Act? The facts of this case were briefly, the general contractor entered into a subcontract with a subcontractor. That subcontract was either terminated or abandoned. And then a sub claimed that they were unpaid and filed liens to the tune of about $275,000. So in this case, the owner and the general contractor wanted to take advantage of Section 23 to not only discharge the liens, but also discharge the owner's liability going forward by paying into court 10% of the amount of the progress draws paid. So going back to my, if you think back to that construction contracting chain, we have liens filed by we have liens filed by sub-subs. The general contractor is saying, hey, look, here's the total amount paid. This is the total amount paid to the subcontractor. And we're going to pay in 10% of that pursuant to Section 23 to discharge the liens and to discharge the owner's liability to those, lien claimants going forward. And now the amount that was going to be paid into court was less than the amount of the lien claims. The 10% of the progress claims only came to about $180,000. All of the lien claims were $275,000. So of course the court, so now you've got the court having to determine, well, what was the amount of the holdback? What was 10%, the 10% greater value, the value of the work provided under the contract or the amount of the invoices? Now, the value of the work and materials actually provided under the subcontract was at issue because the subcontractor claimed that they were actually still unpaid invoices to the tune of about $777,000. So basically, the owner wants to pay in, the owner and general contractor want to pay in 10% of the invoices issued, but the subcontractor has put evidence forward that, hey, actually, that doesn't represent the value of our work. The value of our work was much higher. So all amounts were in dispute. The parties are presenting conflicting evidence. The petitioner argued that the court was able to determine what the appropriate amount of security should be. The petitioners, the owner and the contractor, argued that, well, look, if the deficient and incomplete work by the subcontractor had been factored into the holdback calculation, the value of the work provided would be actually a lot lower. We should only be paying $145,000 in. Hey, look, we're prepared to pay 10%. You're getting a great deal here. We're prepared to pay 10% of the invoiced amount into court instead. The owner and the general contractor are relying on affidavit evidence. The affidavit evidence is coming before the court on short notice, so quickly. And it also includes information without disclosing the source of that information. So there was some questions about the type of evidence that was being relied on. So the respondents argued that the appropriate amount of the holdback should not be determined by way of this court application. That this matter should go to trial because, as we mentioned earlier, we've got the subcontractor saying, well, the actual value of my work was much higher than what the owner and the general contractor say. So was the court able to determine what the holdback was? Could they determine what 10% value they should be paying into court? Now, the petitioner's owner and general contractor are citing authorities that, look, deficiency set-offs can impact the calculation of the amount that a contractor owing by a contractor to the subcontractor under Section 23. But the court said, look, you've given us some authority on that point, but you haven't given us any authority that says that deficiencies can be taken into account when determining the amount of a holdback. And so here the court's saying, look, it's not possible on the evidence for us to determine what amount should be paid into court. So the key takeaway here is that you've got this mechanism to remove a lien claim. And this mechanism sounds like a great idea because the owner is able to also discharge their liability in addition to having the lien removed. But the petitioner needs to have clear and uncontroverted evidence of the amount owing as between the payor and the party that engaged them below the lien claimant. And so if you're bringing a Section 23 application, any discrepancy or dispute on the amount of the required holdback might result in a finding that the issue has to be determined at trial. I've got a few more minutes. The next case I'm going to talk about talks about strict compliance with the Builders Lien Act and certificates of completion. Certificates of completion are often an area of confusion for owners and consultants. So as you may know, there's different triggering events under the Builders Lien Act to file a lien. So Section 20 of the Act says that it's either the issuance of a certificate of completion. If there is no payment certifier or certificate of completion, then you look to the completion, abandonment, or termination of the head contract. And if there is no general contractor, well, then you're looking at completion or abandonment of the improvement as a whole. So the Act sets out the different triggering events to file a lien, one of them being the issuance of a certificate of completion. And Section 7 of the Builders Lien Act requires that, with respect to certificates of completion, Section 7 of the Builders Lien Act requires that on the request of a contractor or subcontractor, the payment certifier must determine whether a contract or subcontract is complete, and they must do that and issue a certificate of completion within 10 days. And then if a certificate of completion is issued, well, notice of that certificate must be posted on the site within 7 days. And then under the Act, a claimant has to file their lien no later than 45 days after that certificate was issued. So there's a scheme, and a strict scheme, I'd say, set out under the Act as to how a certificate is issued. Oftentimes that strict scheme is not followed. And this case sort of deals with, well, what happens when things go awry? The main issue in the Clough Pacific Joint Ventures case and AECOM Canada was, well, did the certificate of completion and that notice of certification of completion meet the statutory requirements so as to trigger the lien filing period? Let's talk about the facts briefly. Subcontractor here hired AECOM to do some geotechnical work. A payment dispute arose. On August 2nd, 2024, AECOM files their lien. And then the subcontractor seeks to remove the lien, claiming that, well, look, it's filed way out of time. There was a certificate of completion issued with respect to the subcontractor's work on July 26, 2023. And the notice was posted in August of 2023. Well, AECOM turned around and said that, well, look, the certificate of notice didn't meet the statutory requirements of Section 7 under the Builders Lien Act. Therefore, our 45-day timeline was actually never triggered. So what happened here is that the request was made of the payment certifier on July 6, 2023. But the certificate of completion was issued 20 days later, not the 10 days later as set out under Section 7. And then the notice was posted 17 days after that, not within the 7 days as set out in the legislation. So although the subcontractors argued that, well, all this did was just delay the 45-day timeline from starting, the court held that no, that certificate and notice that you're relying on to say trigger the lien filing period, well, that's invalid. And this 45-day deadline had never been triggered by that certificate or that notice. And they found that and lucky for AECOM, they found that their lien was filed in time. So some of the key findings in this case are that the Act is technical. There's one of the main goals under the Act is to provide certainty and fairness for the stakeholders. This subcontractor didn't have any control over issuing that certificate or that notice, but they suffered the consequences of it by having a lien filed beneath them. The court would not treat the deadlines for issuing and giving notice of the certificates of completions as just suggestions, particularly here when you've got the subcontractor holding AECOM to that strict 45-day deadline. Well, of course, and the courts are saying it works in the reverse. AECOM can also hold you to the strict deadlines within which to issue the certificates and the notices. And it's the case is also significant because we should highlight Section 7(9) of the Builders Lien Act, where a payment certifier is liable to anyone who suffers loss or damage as a result of the certifier's failure or refusal to comply with the timelines issued for these certificates and these notices. So if that payment certifier's failure to issue within the express timelines then cause that subcontractor damages, well, that payment certifier is exposed to a claim pursuant to Section 7(9). I do see some questions coming in, and I've got two more cases that I wanted to talk about. Let me just confer with Scott. Scott, what do you think? Do you think I should sign off now, or do we have time for me to go through one more case?
I think what we should probably do is it's about 12:38 now. I've got some good stuff to go through, and we'll see where we end up at the end. And hopefully we've got lots of time for questions.
Okay, well, if we don't have as many questions as we were anticipating, I'm happy to touch on risk of double payment under the Builders Lien Act and breach of trust and director's liability at the end. Okay, so I'll turn it over to you now, Scott.
Thank you very much, Satinder, and thank you for that great presentation, particularly on prompt payment. And hopefully we've got some good discussion happening on prompt payment going forward after I finish my presentation. So charge up your coffee mugs and hopefully you're ready for a little bit more of what we've got to talk about today. And my section is really going to talk about some recent case law in the last year or so concerning delay claims and termination of contracts. And I'll also be reviewing the important updates to the CCDC suite of contracts, dealing with the CCDC 5A, its companion contract, the CCDC 17, and the CCDC 5B contract for construction management. So the first thing we want to talk about is delay claims, and in particular, this case, Walsh Construction versus the Toronto Transit Commission Authority. And delay claims, and just prefacing this a little bit, delay claims are one of the most controversial and common problems in construction projects. And we've seen data that says that about 25% of all construction projects in Canada are delayed. So you can see this is going to come up time and time again. And the amounts are often difficult to prove, and you often are required to have expert evidence to pursue those claims. So it becomes important when we see a case like Walsh Construction come along. And the Walsh Construction case, the facts of that are important. The Toronto Transit Commission, the TTC, engaged Walsh as a general contractor to build a subway station. The project was significantly delayed, achieving service over 1,000 days after the original completion date. And then Walsh claimed on 23 heads of damages. Those actually totaled $193 million. So these are significant damages. In such a situation, you're often going to be, in that case, of course, dealing with expert evidence. And Walsh claimed that the design was incomplete when the contract was signed. This was exacerbated by lack of access to the site, and what they alleged was the TTC's improper contract administration. And one of the key things here is that Walsh advanced its claims on behalf of its 22 subcontractors and for their delay and acceleration costs. So the issues became the status of the flow-through claims. Now, was Walsh entitled to the damages relating to those 22 subcontractors? And the second major issue was the expert evidence. What's the role of an expert evidence in determining a compensable delay claim? And when we look at the facts related to the flow-through claims, Walsh argued that it was entitled to recover from the TTC, including its subcontractor claims. And but importantly, the TTC only contracted with Walsh. There was no privity of contract between the TTC and the subcontractors. So the subcontractors could not claim directly against the TTC and only through Walsh. And these flow-through claims were effectively a procedural device to get around this basic contractual law that you have to have a privity of contract, you have to be a party of the contract in order to make a claim. Now, the TTC, in response, argued that the damages claimed by Walsh must represent damages which Walsh could itself be potentially liable to its subcontractors. And in that regard, Walsh had executed what are called liquidating agreements with these subcontractors, under which it paid all the subcontractors for the amounts that they were owed and released Walsh from liability. So the TTC simply argued that Walsh had no potential or actual liability to these subcontractors, and therefore their flow-through claims should fail. And the court held on this that a flow-through claim is only a procedural device. It's not a cause of action of its own. And for Walsh to be able to pass through that liability up to the owner, the TTC, there has to be at a minimum a potential liability between Walsh and its subcontractors. But because they'd already been fully released, there was no basis in which to find the TTC liable for those subcontractor delay claims flowed up through Walsh. And the court determined it was improper to place liability on the owner when the owner had not contracted with the subcontractor. Now, this is under appeal to the Ontario Court of Appeal, so we're waiting for a decision on that. And it'll be important because these liquidating agreements are commonly used in the U.S. and have been considered and are deemed to be a suitable device to flow through liability from subcontractors through a general contractor all the way up to a general contractor. So we'll wait to see what the Court of Appeal in Ontario says about that. The next issue was the expert evidence. And that often when you have a delay claim, it's determining how much of a delay on a project was caused by each party and whether that delay should be compensated, whether, in short, it's a compensable delay. And on a complex project involving a lot of moving parts and potential concurrent delays, it becomes important then to have that expert evidence and for the court to properly analyze it. Now, the TTC argued that Walsh had the onus of proving the delay, and it was the sole responsibility. And then Walsh claimed that it met its onus through its expert evidence that it provided in an expert report on the construction schedule and the delay analysis. The TTC alleged that the Walsh expert was biased in his methodology, although the court went through the test of admissibility to determine whether it would be admitted on the criteria of relevance, necessity, absence of exclusionary rule, and a properly qualified expert, and determined that that was satisfactory. Now, in response to the Walsh expert report, the TTC's expert only critiqued Walsh's expert methodology without conducting their own assessment or advancing comparable evidence. And that became a critical factor. So the court, in response, found that the expert evidence of Walsh was fair and objective, and that they did have a methodology for which to analyze the delay claims. Now, the difficulty for the TTC is if the expert is called by one party in an adversarial proceeding and but the TTC failed to ask Walsh expert questions that may have established the partisanship, then it was really incumbent on the TTC to provide their own expert report and analysis of the compensable delay claims so that the court could evaluate both. And so the court, in this case, found that Walsh's expert evidence was sufficient to persuade it that there was over 1,000 days of compensable delays, and the court had no other expert evidence in which to engage on that analysis. So takeaways here: flow-through claims, they're a procedural advice, not a cause of action. And for a flow-through claim to exist, there must be potential liability between the general contractor and the subcontractor. And if you contract out of this, that may end the viability of a flow-through claim. The expert evidence in the context of complex construction project with many moving pieces, a court will typically rely on expert evidence. Each party should have its own construction delay analysis and compensation delay opinion in those circumstances of complex and large-scale construction projects. And so we'll wait to see what the Ontario Court of Appeal says about this. And so that will be important to see if they affirm the trial division. The next topic we want to talk about is contract terms, and specifically the issue of the common dilemma in construction projects where the contractors and subcontractors is what to do when they're not being paid, and do they continue to do the work or refuse to do the work. And a good case that looks at this issue and provides some analysis and guidance is this Campus Contracting and Torbear decision, again from Ontario. And the facts here are that Campus Contracting, the subcontractor, was engaged by a general contractor, Torbear, to connect and install high-pressure water mains and sewers in a fixed-price contract. Now, due to testing, the pipes installed by Campus failed repeatedly. Campus informed Torbear, the JGC, that it had not received payments on its draws, and therefore wouldn't investigate or repair the leaks in the piping. And Torbear denied that any amount was owed to Campus and had said you had not completed your work. Campus had worked until August, then stopped due to non-payment. Torbear, the GC, then sent a notice of default and 3 days later declared Campus in default pursuant to the termination procedure specified in the contract. And Campus brought an action for breach of trust and a claim on the labor and material payment bond. Torbear counterclaim for damages. Now, the trial judge, looking at this, he split it in two parts. He dealt first with the determination on the liability for breaching the contract, which was really the preliminary question that needed to be answered before they could move into the other issues on the trial. And so specifically, did Torbear breach the contract for non-payment of the progress draws? And did Campus abandon the project, or did Torbear unlawfully terminate that contract? And the court found that Campus had not complied with the payment process in the contract. And the invoices were sent to be sent each month, and with payment due at the following end of the next month. And therefore, the money claimed by Campus in early August was actually not due till the end of September. So the court found that the GC Torbear had not breached the contract. And the court also found that the contract required Campus to install those pipes properly, and Campus did not do that, and therefore did not complete the contract. And so Campus's claim for non-payment was not supported by the evidence, and Campus tried to claim that it was unable to complete the contract because of circumstances outside of its control. But the court wasn't persuaded that these issues amounted to a fundamental breach or frustration, allowing them to not complete the contract. So therefore, Campus was found to have breached the contract and abandoned the project when it failed to continue back in August of that year. So in terms of takeaways, in a fixed price contract where a party refuses to complete a contract due to non-payment, you do so at your peril. The contractor or subcontractor must be certain the payment is due and owing pursuant to the payment terms of the contract, and that the non-payment goes to the root of the contract to support the decision not to continue the work. And if that certainty is not present, the contractor or subcontractor is at risk of being liable for breach of contract and not performing as required by the contract. So the next topic we want to talk about, changing gears a little bit here, is updates to the CCDC that happened this summer. And there were a number of updates that occurred, and we want to just walk you through some of those. Now, by far and away, just to preface this bit of our presentation, by far and away, the most commonly used construction contract forms in Canada are the CCDC suite. And I think a number of years ago, we did a presentation. We actually had a poll that we put out to our attendees, and we had a lot of attendees. I think it was actually going all the way back to COVID time. But we found that almost 70% of our audience, which is largely contractors and consultants and lawyers, that they use the CCDC suite. And of that, about 7% of the time they were using the CCDC2 fixed price contract. Now, what we're going to talk about here is the I get stuck here for a second here. Yeah, we're going to talk about the updates to the CCDC 5A, which is the construction management contract not at risk. And of course, it has its companion contract, the CCDC 17, where the owner enters into the contracts directly with the trades. And then the other version of a construction management contract is the CCDC 5B, which is the construction manager at risk, where the construction manager actually enters into the subcontracts with all the trades. Now, when we look at those, these updates in general, what is really happening is that the CCDC committee has trying to update these documents that haven't been updated since 2010 to align with the changes in the CCDC fixed price contract, the CCDC 2, that occurred in 2020. So there's a lot of attempts to align it, but also looking at what happens in construction contracting, what people are typically doing in supplementary conditions. So some of these changes reflect what are common supplementary conditions that many of us insert into these contracts. I would say also, though, even with these changes, that supplementary conditions are still going to be required. People are still going to do it because there's still gaps and things that are not included here that you need. A good example would be there's no provisions dealing with responsibility for liens. And typically it should be in a CCDC 2, it's the general contractor that usually takes responsibility for its trades and dealing with liens. So that's something that some gaps that are still there. One other thing just to note about these reforms that were made, there was also another reform made to the CCDC 30. The CCDC 30 is the integrated project delivery contract, and they updated that with a lot of lessons learned over the last number of years as that form of contract seems to be getting a little bit more popular. We've just actually put out an article, which if you check or you ask Satinder and I, we're happy to send to you, is on the summary of those changes for the CCDC 30 IPD contract. Okay, so let's get on with it. The next thing here is really dealing with these specific issues. So the first one that comes up is the ready for takeover. This was something that was found in the CCDC 2 and its reform, and is an important addition to the construction management documents. Now, the statutory substantial performance of the work is essential for typically triggering lien periods and holdback releases. Now, under the old contracts, substantial performance also triggered occupancy, warranty commencements, and insurance obligations. So what the ready for takeover concept tries to do is tries to better align the contract with those legal milestones and provide some practical operational readiness. So ready for takeover is verified by the consultant and will conclude to get qualified as ready for takeover. You will need compliance with occupancy permits, regulatory requirements, cleaning, delivery of operational manuals and that sort of thing. And importantly, of course, delivery of as-built documents. Now, before the ready for takeover happens is another issue. Early occupancy. And early occupancy, we often would draft into contracts because you have large projects where the owner may sequentially occupy certain parts of it for further work or even operational use. And so you get these provisions trying to deal with and cope with early occupancy. Now, the amendments here formalize obtaining early occupancy. And that enables the owner, again, to take occupancy before this ready for takeover milestone. And the difficulty that we flag here for you is that what you don't want is your early occupancy necessarily to trigger ready for takeover achievement, because then it triggers things like warranty periods that you may not want to run so soon when even the whole project is not even complete. So you have to be really mindful of that, and that may be addressed in supplementary conditions. Another innovation here is the pre-construction services and fee structure. Again, we often put into supplementary conditions trying to deal with pre-construction services provided by construction managers. This is dealt with in a lot of progressive or collaborative contracting, where that construction manager performs a role early in the project, providing assistance with design, even, but certainly budget and schedule. And so that creates a model for dealing with that, and for payment of those services. And so that's a welcome innovation, and reflects a lot of what's going on in the marketplace. The next one is payment obligations, prompt payment. It specifically inserts references to prompt payment because, of course, in the rest of the country, they've had prompt payment earlier than we have, and we're lagging a bit here in BC. But as Satinder said, we're on our way, and you should all be aware and take note of what Satinder's outlined for you. We don't know exactly when that will actually be brought into force, so it might be some time. So while there are specific references to prompt payment here, and specifically, it does structure it so that construction managers and trade managers must submit the monthly applications for payment, and the owners are required to pay in 28 days, and they must meet the statutory requirements for proper invoice. Now, given that we're not quite there yet, you may want your supplementary conditions to delete those references, because we don't have yet actual enforced legislation. So be mindful of that as well. Another concept that I think is welcome is progressive holdback releases. So the progressive release of holdback now applies to all work, including that performed by the construction manager. So a helpful change there. And then something that is often comes up in supplementary conditions negotiated between the parties is termination for convenience and without cause. Now, often parties, and particularly our owners, don't want to have to prove that there's default, and want to be able to simply say, I can terminate with sufficient notice to you, but without any cause of default. Now, what you can see in there is, with that right to terminate without cause, is that on a termination on a pre-construction phase, the construction manager is entitled to what is called a break fee, and that's based on a percentage of the actual construction cost estimate. And then for the construction phase, the construction manager may claim direct damages, including reasonable lost profit, on a termination without cause and for convenience. So there's some things that arise here that you need to be mindful of. One query is, do direct damages include lost profit? Arguably yes, but maybe they need some clarification. Really, should they be entitled to lost profit? When you think about particularly the CCDC 5A, the construction manager is not at risk. And effectively, they're just another consultant on the project. Should they be entitled to something like lost profit? I don't think so. But that's something that is often an issue. And then we're looking for the related issue, and it's probably one of the most significant issues, is the limitation of liability. Under the CCDC 2, there is effectively some limitation of liability provisions, and these new provisions are an attempt to mirror a little bit of what's going on in the CCDC 2 fixed price contract. And in the 5A contract, it's saying that the maximum liability of either party, so either the construction manager or the owner, to the other is the greater of $2 million or the fee for services, to a maximum of $20 million. But that's the fee for services of the construction manager, not the cost of the work or the contract price. And that's the key difference with the CCDC 5B and the 17, where the cap is the greater of 2 million or the contract price, also to a maximum of 20 million. There's also in there a mutual waiver of consequential damages and while that's often put into contracts or negotiated as what the appropriate elimination of those types of damages is, but the parties really have to concentrate their minds as to what really are consequential damages. Do they include lost profit, lost opportunities? Do they include financing costs? Do they include lost condo sales, lost rental revenue, delay claims? Clarification of that becomes really, really important. So I would not, once again, I would say you've got to look to your supplementary conditions to provide some clarity and certainty to the parties. And so I would suggest that we haven't eliminated the need or the negotiations over supplementary conditions. And that's it for me. That's questions. And I think we got to just a little bit after 1 o'clock, and hopefully we can have a good discussion about some issues that have arisen, and I'm sure people want to talk about prompt payment. So, Inder, you've got some in there in the chat box.
Yeah, so I'll address the first question here. Thanks for the question, and I'm going to amend my slides. The question is, why doesn't the language use the date the invoice is issued rather than dated? So indeed, the proposed bill, when it talks about payment being due from the owner to the contractor and down the construction contracting chain, it does say the date of the invoice date, that it's 28 days after the invoice date. But then if you go back and you look at the definition of invoice date, it reads, in relation to a proper invoice, invoice date means the date a contractor gives the invoice to an owner. So in effect, it is the date that an invoice was issued, not the date that the invoice is dated. Although the Act, if you look at this, when you look at the language of the Act, they're using invoice date, and then they define invoice date as the date it's issued. So it's important to keep in mind that we are going that 28 days will. So the takeaway here is that 28 days will begin to run from the date that the contractor gives the invoice to the owner. And we can talk all about how that can be confused and misconstrued and whatever the case might be, but those are all the issues to deal with for a different day. Never got it. Yeah.
Never got it.
Never got it. The next question is, could you please summarize the relationship between the Builders Lien Act, the Prompt Payment Act, and a Shimco lien? Yes, good question. And really, you know, we would love to spend more time on these issues. We find ourselves sort of sometimes having too much to talk about in the time we allocate ourselves. So the distinction between, and I think this is also important, the Builders Lien Act and the Prompt Payment Act is that the rights, obligations, and duties with respect to parties that carry out work on an improvement and the right to lien, all of that will still be in place. Lien rights are still, lien rights are not affected by the proposed Construction Prompt Payment Act, other than the slight ways in which it might amend the Builders Lien Act. So the lien against the land, that subsists under the Builders Lien Act and all of the other rights and obligations between the parties. Whereas the Construction Prompt Payment Act, the goal and intent of that is simply focused on when payment has to get made. So you see it as a subset of the larger Builders Lien. I guess you could see it as a subset of the larger Builders Lien legislation, but really the objective of the prompt payment legislation is to see money flow down the construction contract chain, and then also add a mechanism to address disputes. None of those things are addressed in the Builders Lien Act. The Builders Lien Act sets up a scheme by which a party can secure the amount of work and the value of the work that they've done for an improvement by way of filing a lien. Now, so I've just gone on and on about how these are two distinct pieces of legislation, but there is one key way in which the Builders Lien Act has been amended by the prompt payment legislation, and that is the Shimco lien. So let's talk a little bit more about what the Shimco lien is and how in the, before the legislation comes into effect, who might be considering enforcing their Shimco lien claims before the change comes into place. So Section 4(9) of our Builders Lien Act says that a holdback required to be retained is subject to a lien under the Act. And so in the leading case, Shimco, our courts confirmed that this lien is a separate and distinct lien than the lien that is than the lien that you file against the land pursuant to the Act. So this is, you can go ahead, file your lien within your 45 days, liens filed against the land, and then you can move forward with your rights to enforce that lien claim. Let's say you miss that 45-day time period. Well, in BC, what you get to do is, if the holdback with respect to your contract has not been paid out, or the holdback on a project has not been paid out, you can commence a Supreme Court action to enforce your claim, to enforce a claim of lien under the Builders Lien Act for those holdback monies. And that's a separate lien. It's a lien enforced by way of a court action. It doesn't encumber the lands like a builder's lien does, but it can often be an effective collection tool. Now, all of a sudden, once you've commenced that action to enforce your claim as against the holdback can't be paid out. Should keep in mind, though, that you can, if you commence an action to enforce a claim of lien as against the holdback, and the holdback has already been paid out, well, then your lien rights have been extinguished. There is no holdback for which you can claim a lien as against. Hopefully that summarizes how the two pieces of legislation, the existing Builders Lien Act and the proposed Prompt Payment Act, how they operate parallel to and separate from one another, but of course address industry concerns. And then the one key change that the Construction Prompt Payment Act makes to the Builders Lien Act by way of
just to really underline to the folks out there that when this comes into force and there's no more Shimco lien, you have to be very, very mindful of your time requirements of 45 days from substantial completion to get your lien filed. Otherwise, there's no saving grace of, oh, well, we'll just start a Shimco action and you'll be able to share in the holdback like everybody else. You will be out. No holdback for you. So really, really important to note that change. We've all become very comfortable with the idea of a Shimco lien over the last decade. So I think that change is something that people really have to focus on when that comes into force. Not there yet. Still have Shimco liens, but we're marching towards it.
The next question is, the next question to me has a lot of layers. It starts off with, can we issue certificates of completion for the base contract amount when a delay claim is being negotiated? And if the claim is settled, the delay claim is settled after the certificate of completion has been issued for the base contract, should another certificate be issued for the settled delay claim? So when I say that the question has a lot of layers, the first thing I think about is, well, is the certificate of completion being issued pursuant to the Builders Lien Act? And so if a request has been made of the payment certifier to issue a certificate of completion for the general contractor's head contract, and there is a dispute as to what the contract price is because of a delay on the project. Well, I can see why that payment certifier, the consultant, would be scratching their head. Well, what do I do now? I've got these obligations under the Builders Lien Act to issue a certificate within a certain number of days, but the parties are arguing over the parties. Yeah, thanks for the clarification. Yes, it is based on the Builders Lien Act. This was regarding progressive release, by the way. Yeah. So, what do you do as a payment certifier? A request has been made of you to certify that the contract is complete, but the parties themselves are debating over the contract price. How do you apply the 3-2-1 formula under the Act to that dispute? Do you, as a payment certifier, say, sorry, the contract price is not clear. I can't apply the 3-2-1 formula in these circumstances because the contractor is taking the position that based on their delay claim, the contract price is an extra $3 million or whatever the case might be. Might be an exaggerated example. So I think in those circumstances, and I hate to be wishy-washy in my answer, but I think that what you would have to do is you'd have to determine that on a case-by-case basis. If you are applying that 3-2-1 formula and notwithstanding the delay claim, you still meet that 3-2-1 formula, I think that you could issue your certificate of completion. If you're applying your 3-2-1 formula and you're coming up with completely different numbers when you're looking at the alleged delay claim versus the contract price, then me as a payment then in advising the payment certifier, I would probably go the more the less risk adverse route, which would be to paper the fact that, look, because of these circumstances, I can't issue a certificate of completion. I can't determine what the final contract price is. And I have advised consultants accordingly on projects in the past where they're stuck between a rock and a hard place, between the owner taking a certain position as to what the contract price is and the general contractor or the other contracting party taking a very different position as to what the contract price is. And all of a sudden now you can't issue your certificate in order to release holdbacks. I know you're in a difficult position as a payment certifier in those circumstances, but that would be the risk adverse advice that I would give, is that you'd have to look at the circumstances, look at the numbers. And if you, at the end of the day, cannot with certainty say what the contract price is, then you can't be issuing your certificate of completion. Do you agree, Scott, or do you think I'm being too
No, if you've got a delay claim,
conservative?
it's really what is that delay claim? You know, you're seeking an extension of contract time. You're seeking potentially an extension or increased contract price. Compensable delay claim, and so calculating. Well, how long does that take you out, and what's the value of all that work to be done? And that can affect your trigger dates for your 3-2-1 formula and your right to get progressive release of holdback and that sort of thing. So it's a strategic question that you have to ask yourself of your claim and what you want to achieve.
And I think if it's a scenario where it's your GC asking the owner for a certificate of completion, so that the GC can have their holdback. Well, come on, GC, you don't get to advance a delay claim and say that the contract price has gone up, and then at the same time say, okay, and now I want my holdback as well. I just does, that's not making a lot of sense to me.
Can't have your cake and eat it too.
Yeah. I hope that answered the question. It is for an excavation. It was done months ago. Claim is still ongoing. It is increased price and the scope. Okay, so the excavation scope of work is an issue. And I'm assuming that a request has been made for a certificate of completion for that work, but there's a dispute as to the value of that work. And I would apply that 3-2-1 formula. And if you can't certify completion based on the 3-2-1 formula, well, Yeah, I think you're in a tough spot. I wouldn't be issuing a certificate of completion. If the contract price, if you as a payment certifier cannot determine what the contract price is.
Any other questions in
You're
there?
welcome. You're welcome. All right. Well, if there isn't any other questions, we're happy to wrap up a little bit early, unless there's a burning request to talk about director's liability under the Builders Lien Act, and the risk of double payment. I think we've gone through a lot of material.
Save it for next time. We've
Save it for
held
next
your
time.
attention for well over an hour, so I think that's pretty good. And thank you very much for attending our seminar. And as Satinder will outline, we've got more coming certainly in the new year as prompt payment rolls forward and issues with prompt payment, and more stuff and developments in contract law for construction. And so we look forward to seeing you again.
If there's any questions about some of the slides that we didn't review in the presentation today, then feel free to follow up with us. You've got our phone numbers, you've got our emails. We're happy to follow up afterwards. Great. Thank you.
Thanks, folks. Bye now.